Lucy.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. It is Friday, so it is Ask a Lawyer. I'm a real one. I'm licensed by the Florida Bar and everything.
Not just playing one on the radio.
I'm not just playing one on radio or TV. So if you have any questions about any topic, give us a call. If I can answer them, I will. And if it's really not my area of the law, I'll be honest with you and tell you that I can't. So today, we're going to go into a new area. We're going to talk about something that actually came up in my office this week, and I had already planned this. So it's interesting how it occurs. We're going to start talking about non-compete agreements that you may be asked to sign if you're an employee, either when you start a job, sometime while you're in the middle of the job, or perhaps even just before they're getting ready to fire you and you don't know it. So it's an interesting topic, and it's a topic that we actually do get a lot of phone calls about.
Okay.
Because it has very significant consequences. But before we do that, I want to talk a little bit, tell a story, I guess, which has a point to it, and that is we actually got a call this week from somebody who heard me on Ask a Lawyer.
Awesome.
Which is wonderful.
Yeah,
I love that.
That's how it's supposed to work, right?
That's right. And they came in on a employment matter, and they thought they had a breach of contract case because they have a written employment agreement that says they're supposed to be paid a certain amount of money. And all of a sudden, when they got their tax forms for this year, they looked at it and said, something's not right here. Because, direct deposit, you don't always look at your pay stub.
Or what was deducted even.
I'm going to say something about that in a second.
Okay.
And it turns out she was underpaid, let's just say by more than $10,000.
Wow.
From what the contract rate was. So she came in believing, and I think absolutely correctly after I reviewed the contract, that she has a contract claim against her employer. Not a big one, but $10,000 or $15,000 or whatever it really was.
Well, that would have went a long way during the year.
Absolutely. Now, the interesting thing is she came in, and I'm looking at the contract, and I see that she was an occupational therapist. Now, what did we discuss last week? We talked about exemptions to overtime and what was necessary to be exempt. And if you were not exempt, the obligation of the employer to pay you time and a half for all hours over 40. Now, she did not come into my office thinking she had an overtime claim.
Right.
She came in for a breach of contract claim.
There was a little shortage going on there.
So when I heard not only her title, because it doesn't go based just upon title, it goes based upon your duties and responsibilities. And when I listened to what her job entailed, a little red flag went up, and being that I was in my office, I jumped on my computer and did a little quick searching, found what I was looking for. And I said to her, do you realize that you might very well be entitled to overtime going back 2 years, or if the failure to pay you properly was willful, 3 years? And she looked at me quizzically, and I explained to her that the exemption in terms of being an occupational therapist, I had to do a little bit more research, but it appeared to me that she did not qualify to be exempt.
Okay.
And we were looking first at the professional exemption, which we talked about last week. And while she was making the right amount of money, she wasn't supervising anybody, and her extended course of study, which is what's required for the professional exemption, there's a lot of case law out there that says occupational therapists, physical therapists, that's not what was meant by an extended course of study. She had a bachelor's degree, and a bachelor's degree is typically not sufficient to qualify for a professional exemption. Even some additional coursework you may have to take to get a certificate, or maybe even licensed by the state of Florida in certain occupations, that is very often not sufficient to qualify for the professional exemption. What is necessary is that you engage in a course of study that takes a period of time to accomplish and is beyond that which the average person would engage in. Usually it requires a master's. In some situations it requires more. So I happily accepted her case, both for the contract claim and told her that I would be doing some additional research on overtime issues. And if it played out as I expected, and I still was of the opinion after the research that she was entitled to overtime, that her overtime claim was probably worth several multiples of the contract claim she had come in about. So there are really a couple points there. One is, it's nice that somebody's listening. It makes me feel good.
Yeah. What's better, though, is you're going to be able to help this person.
Yes, it is. And interestingly, she came in because she heard me discuss one thing. Maybe she wasn't listening that day when I was talking about overtime exemptions. Who knows?
She didn't think she had any.
But then you come in and sometimes you find out you have either claims.
She found out it was worse than she thought.
Right. Well, yeah. You find out you have claims that you didn't have.
Yeah.
Or sometimes it's the reverse. You come in thinking you have claims, and after we
Right.
really go through it,
You really got nothing.
I have to say to you, you don't really have a claim, and here's why. And some people are very accepting of that. Once they understand, they're able to move on. Others are not exactly happy. And, my standard pitter-patter, in those types of things is, if I'm telling you that I don't think you have a case and therefore I can't really help you, always go talk to at least one other lawyer. Lawyers have different opinions. We have different perceptions. We have different backgrounds. And, I would never presume to say that if I don't think you have a case, that is absolutely the final end of it.
Okay.
There are plenty of people who have come to me and said, well, I've been to 2 or 3 lawyers, and they all don't think I have a case. So I'm already in my mind preparing, well, I guess if multiple lawyers have said you don't have a case, you probably don't have a case. And I go through it. We have our normal consultation. I look at documents. I listen to them. And I come to the conclusion I disagree. I think you do have a case. And that happens. So, just like you might search for multiple doctors or get second opinions, do
well,
it
I'm
with lawyers
thinking
too.
you may catch that attorney at a time when he's extremely busy.
True.
And maybe your case is sort of iffy, and if he puts the time in, and right now he's just too busy.
That's true too, and hopefully the attorney is honest enough to say that, which leads me into the second story of this week. I had a couple of ladies come in with a possible sexual harassment case. And as I was listening to the facts...
What was that, hashtag Me Too?
It really should be, but
Yeah.
it was. I can't say much more because the other side doesn't know what's about to come.
Okay.
And I don't want to give away anything.
No.
But they came in for what was scheduled to be a 2-hour consultation. They were in my office for 4 hours. Why? Not just so that I could review the materials and explain the law, but they were skittish. Understandably. You look at all the people that have come out over the last several months with regard to sexual harassment in entertainment, politics, sports, TV, and the reasons that they've expressed for not coming out sooner. And it is understandable that a woman, particularly who is being subjected to sexual harassment, may feel a wide range of emotions, not limited to embarrassment, some feeling of maybe they brought this upon themselves, and not want to come forward right away or not want to make it public to an employer. They were a little bit concerned about once I send out a demand letter and the employer knows that they're complaining, what happens to them?
Oh, well, I don't know. I mean, you're not happy going to work there anyway.
That's true, but I've had many clients
Yeah.
who have willingly gone back under those circumstances. I let them know that retaliation is also prohibited under the statute. And if anything starts to happen, let me know, and we'll figure out whether it constitutes retaliation. And there are other clients who say, once I tell them what's been going on, I want to be as far away from that place as possible. I just can't possibly go back once they know.
It depends, though, if that you're being harassed by an employee or if it is the actual manager or owner of your business.
That is also correct. And so in this situation, they did not want to go back once the bird was out of the cage. And I explained to them that as much as I understood their reasons and as much as it made sense on a human perspective, the law says, Supreme Court has clearly stated that you must give your employer an opportunity to investigate and to take prompt remedial action, or you lose the ability to sue the employer. And usually the employee doesn't really have deep pockets. And so for people in this type of a situation, which is understandable, I try to create one of a couple of scenarios that serve their interests and the legal interests as well, which is we prepare a little email or something that gives the complaint, which satisfies the statute, and either they survive it for a week and then say, I just can't tolerate this anymore. You haven't done anything about it yet. I'm gone. And I think I can argue that effectively.
And would they have to take those, give notice and all of that?
Not really.
Okay.
Not in those situations.
Okay. So it's because you've been told that this is going on and you haven't
Right.
corrected it, I'm out of here.
Yeah, one of the legal phrase for it is a constructive discharge. The other thing that we can do is if they're really, really, really afraid to go back to that job place once they have complained, we can try to arrange, you have vacation time coming? Take some vacation time. You got some PTO time coming? Let's set it up so you take some PTO time. And the day you leave is the day you send that email. And when you're ready to come back, if they haven't done anything, with my helping massage the language, you send another email that says, look, you haven't done anything. I don't feel I can come back. I'm uncomfortable. And therefore, here's my resignation, which I then argue legally is a constructive discharge. So we ended up, the ladies ended up agreeing to sign a representation agreement. And they were concerned. I never really had this one before. Well, by signing this, does that mean my employer is going to find out? No. First of all, there's attorney-client privilege. Second of all, nobody's going to see this representation agreement. It goes into my file. And third, I can't let anybody know anything without your permission. So there is not even a 0.25% chance. The employer will find out when we are ready, when a demand letter is ready, or when a complaint is ready, and when you say, okay, go ahead. That's when that happens. So there were these two cases, interesting ones this week. One came from the radio station, and the lady had a claim that she didn't realize she had, as well as the one she thought she had. And then, the other was something that we may get to today. If we don't, it'll be next week, which is sexual harassment. It may be fortuitous if we got to it today, but we'll see.
Well, we've been promising.
We've been
non-compete.
promising. I've been teasing. I've been teasing.
Yeah.
You know, I've been told.
And I'm on the edge of my seat wanting to know more about that.
Yeah, because I figure the sexual harassment, even though it's part of a broader discrimination in the workplace, it's all part of Title VII of the Civil Rights Act, and in the state courts, the Florida Civil Rights Act. Discussing sexual harassment alone could take a couple shows. Adding the rest of discrimination may take another show. It's a big topic to discuss. So, we're about ready, I think, to go into sexual harassment, and the timing is fairly fortuitous
Sure. Oh, yeah.
with everything that's going on. So tell your friends. I'm making you as much of a promise as I can as a lawyer. Just a little bit better than, please don't call me and complain, just a little bit better than a car dealer. That we're really going to try to get into that next week. So, with all that said, let's talk about non-competition agreements. I represent some employers, mostly 85, 90% or more, I represent the employee. I understand the perspectives on both sides. I understand the legitimate interests of certain types of employers to really protect themselves from certain categories of employees that either resign or are fired. And I don't blame them at all for wanting that kind of protection. And if I'm representing them, I will try to fashion a protection that is survivable of challenge, but is not so broad as to really take unfair advantage of an employee. When I'm representing the employee and I get these calls, the first thing I say to them is, I'm not going to be able to tell you much on the phone. I need to see the non-competition agreement. Everyone is different, and everyone has certain abilities to challenge it, and some of them are just really good, and you're not going to have much luck. You signed it, and that's life. So let's start talking about what these things really are, what the basics are, and then we can go into some of the, the different variations of it, and what can you do about it? Your boss says, here's a non-competition agreement, sign it, or you don't get the job, or if you're working there already, if you don't sign it, you're fired. So your job's at stake. What do? It's understandable to feel pressured, especially if you like your job. But what are the consequences if you really do sign it? And how carefully have you considered that? Because most of the calls I get are from people who didn't really consider it very much and now are in a position where they can't work within a certain geographic radius, which may require them to move.
Non-competes are very big in broadcasting, or they used to be, because broadcasting has changed a lot.
Yes.
Used to be that the talent had a non-compete. Then over the years, salespeople started getting non-competes. So
that's right, and there are different business interests in play. So we start out with, let's talk about Florida law. How do we treat non-compete agreements? It's in the statute. Florida favors non-compete agreements. Florida is not hostile to them. There are states that start with the beginning assumption or presumption that they're contrary to public policy, and you employer need to show a really good reason for it, and it better be really narrow. Not in Florida, folks. Florida favors non-compete agreements, and in fact, if you want to complain about one, a court by statute is prohibited from hearing you argue about how this will affect me or how will this affect my family. Your individualized personal difficulties in living with this non-compete agreement, you can't even argue it to a court.
okay, too bad.
Right. Will not be considered.
Okay.
There are other avenues of attack, but not that. So, Florida, you sign one, there's a good chance that, you're going to be bound by it at least to some extent.
Are there basic things that should be a part of that non-compete,
Yes.
or can they write it any way they want?
Well, they can write it any way they want, and many often do. There are statutory guidelines as to what the courts will presume without further evidence is reasonable, what they will presume is unreasonable, and what falls within a gray area that it's neither reasonable nor unreasonable. It's the evidence that will be presented that will determine if it flies or not.
Okay.
And so let's talk about that. The Florida statute, for anybody who wants to actually go Google it, it's Florida Statute 542.335. That's part of the Florida statutes. Now, there's a lot in there, just like there's a lot in most statutes. There are sections that deal with non-competes, which are also called restrictive covenants, where you are an owner or have an interest in a business and you sell it, and we're not really going to talk about that much, and if it happens to apply to you, give me a call or call the office. And then there's a section that deals with the regular employee. That's what we're going to talk about. So we start out with any non-compete has to have a legitimate business purpose. What is that? It can be almost anything which passes the laugh test, right? If you're concerned about other customers leaving you because of this talented salesperson, talented plumber, talented landscaper, talented anybody, that's a legitimate business interest. If you're concerned about information that they know and they may now transfer to another employer, that's a legitimate business purpose. So I have found that in the non-competes I've reviewed and the non-competes I've dealt with on the other side, dealing with another attorney, and on the non-competes I've had to actually be in court about, the employer is almost universally able to satisfy legitimate business purpose. So now we move on. Florida statute, which has changed every couple of years, really, on what is allowed in a non-compete agreement. And so you must be on top of it because otherwise you're working off of the old non-compete law. The current version of the law, which has been there for a few years, is that a non-compete agreement less than 6 months is presumed reasonable. Now, if there are facts that maybe make it unreasonable, that presumption can be overcome in court with evidence, but it starts out being presumed reasonable. A non-compete that is more than 24 months, more than 2 years, is presumed unreasonable. Now, the employer can show why it's reasonable again if you're in a trial and they have good evidence, but the presumption is 24 months and more, it's presumed unreasonable. So in that big space between 6 months and 24 months, what happens? There's no presumption. It's a case-by-case basis. So employers who are either smart or consult with a lawyer, what do you see? You see 24-month non-compete agreements.
Well, sure. I know. I was just going to say, in broadcasting, if you were a talent coming in, you signed a non-compete that stood for as long as you worked there.
Well, and for how long afterwards is the real
Right,
issue.
right.
Okay.
Well, and there's the weird thing, too, because the non-compete pretty much keeps me, the employee, from jumping across the street. But if I were fired, there are tangles.
If you're fired, it really doesn't matter in Florida unless you've negotiated.
But that non-compete keeps you from working.
Yes. Now, you may have received this non-compete, and you may not be, let's say, the average plumber or landscaper or somebody who really is not going to be able to have success negotiating the terms of the non-compete with the employer. You may be radio talent, TV talent, whatever, and either on your own or with the assistance of a lawyer, you can go back and say, look, I'm willing to sign a non-compete, but I want it changed and this changed and that changed, and you negotiate it. That's fine. I mean, that's something I've done on occasion, and, people have the guts, and sometimes it takes guts to go back to the employer and say, I'm not willing to sign this, because they can then say they're just goodbye.
Right.
But say, I'm willing to sign X, but I'm not willing to sign Y. Depending upon how much that employer wants you, it may be negotiable.
Yeah, they don't want you that bad in radio.
Yeah, it may not be negotiable.
Now, with the overtime, the exempt and non-exempt, there's a dollar amount.
Right.
Is there a dollar amount with non-competes?
No dollar amount. The only two statutory aspects really of non-competes are the time, the duration, which we've talked about now, and the geographic scope, which gets messy. Very, very
you can't,
messy.
If you leave us, you cannot work within so many miles. That's what they're saying.
Essentially. And I have seen non-competes that say you can't work within 5 miles, and I have seen non-competes that say
100.
Worldwide.
No, worldwide.
We're
You can't work.
We're a multinational company.
You are not working anymore.
And funny thing is, some of those are valid. Most of them are overbroad.
I see, just looking at it from a fair point of view, as an employee, if you were to leave, you should be held to the contract. But if the employer kicks you out, you should be able to get a job.
And I agree with you. I think that is an excellent point. But unless you have drafted the non-compete in that way, or unless you are dealing with a reasonable employer who says, under circumstances where you resign, this applies, and under circumstances where you are terminated, if it's for cause, this. If it's not for cause, at will, it's this. There are employers that will do that. That's wonderful. I think that's fair. Sometimes they may be overbroad as well, but certainly it's reasonable.
No, that feels fair.
But most of them, it doesn't matter whether you were resigned, quit, fired, kicked out the door.
Because in this business, sometimes someone signs a non-compete and then they're kicked out really, really quickly. And then they've left one job to take this job, signed a non-compete, and now they have no job at all.
Wonderful point once again. You're so good at this. I have had clients who say, I moved down here from New Jersey because this employer said, I have this job for you. It was a wonderful opportunity, more money for me. I made this whole trip. I sold my house in New Jersey. I bought a house here now, and I've been here a month, and they just fired me. You mean I can't? Well, let me look at it, but yeah, maybe. Doesn't matter. It doesn't even play into it, unfortunately. Should it? Yeah, I believe it should.
Yeah.
In many states, it would play into it. Not
in Florida.
Okay. So all those of you who are now thinking, I'm leaving Florida.
Don't sign a non-compete in Florida.
You may not have a bad idea leaving. There are some things about Florida law which are not very hospitable. So, okay, let's talk about geography a little bit because it really is important, and it really applies to most people that call me or even call other attorneys. Let's say you are an employee and you work for Radio Shack, okay? And you have a non-compete that says when you leave the company, you can't work for 2 years in a 20-mile radius for any company that is in any way engaged in a similar or related business, okay? 20 miles. Doesn't sound that bad, but let's look at the Treasure Coast. 20 miles can get you into Indian River County, the southern end, and 20 miles can exclude you from the northern end of Martin County and all of St. Lucie County.
Yeah.
That now can present a problem for you because you now really got to go much further south or much further north. So sometimes the question is that even legitimate? And in some instances, it isn't. Now, why do I keep sounding like a lawyer saying some? Because
maybe, could be.
Unfortunately, that's true. there is law that gives you the ability to interpret, but this is very heavily fact-based. And so every situation is different. And until I really see the agreement, talk to the client, understand really what's going on here, what they believe the employer's real motivations are, maybe I can contact the employer or counsel and negotiate very simply something that works for both sides, but doesn't land either of them into court where both sides are going to spend lots of money. That's been done.
Mm-hmm.
Sometimes you can buy out of your non-compete. That's another option.
See, and in radio, rarely does that non-compete state what you should be making. It's not a contract that says we're going to pay you X for so many years. That's not even in there.
Well, a non-compete could be part of a larger employment contract. A non-compete could stand by itself, too.
Mm-hmm.
You could have been working there, 7 years. And let's say Mr. Employer comes to me and he says, I'd like to get some advice on how I can protect my business. Well, one of the things I may say to him is, do your employees have non-compete agreements? No. All right, I think you should have non-compete agreements. If you want, tell me what the situations are, what types of employees you have. I'll give you my advice. We'll make a decision. I'll draft a non-compete agreement. Okay. What do I do with it then? You present it to your employees and say, sign it. But what if they won't sign it? That's your call.
Yeah.
The threat can either be sign it or you lose your job, or sign it or from here on in I'm cutting your salary 20%, or anything. That's perfectly permissible. So when you're looking at that non-compete, sometimes it's in a written employment agreement. Other times, a lot of employees don't have written employment agreements.
Right.
But all of a sudden they get a document put in front of them that is either labeled non-compete agreement or restrictive covenant or confidentiality agreement, and you got to read it real carefully. And so, depending upon the situation, going back, the 20 miles may or may not be reasonable. In our local state court, district court of appeals area, which is when if you have to appeal a case in St. Lucie, Martin, Okeechobee, or Indian River, that's our 19th Judicial Circuit. Mm-hmm. It goes to the 4th District Court of Appeals in West Palm Beach. So what we look at is, what has the 4th DCA, lawyer talk, what has the 4th DCA said in opinions? Because that's mandatory precedent on circuit court judges. What has the 3rd or the 5th DCA said? That could be persuasive to our judges, but they don't have to follow it. What has the Supreme Court of Florida said? Got to follow that too. Mm-hmm. Okay. So our 4th DCA have issued cases that are a little more employee-friendly than the statute itself. And they really look carefully at the business interest, not that justifies the non-compete itself, but the business interest that justifies the geographical scope of the non-compete. So there is case law that says it's unreasonable in most circumstances to burden an employee beyond the county in which he or she was employed. Well, to me, that's a little bit more reasonable. It's a little bit more employee-friendly. Now, I've found a couple cases that have said it is unreasonable to burden the employee beyond the city or town in which he has worked for the employer. That's even better because, if it's Port St. Lucie, all right, go to Fort Pierce, go to Palm City, go to Stuart. It's a lot easier than the broader.
See how radio gets a little bit more tangled because you can be heard.
That's right.
In a much larger scope.
And so now, does that justify?
They do. Usually it's like 100 miles.
I don't pretend to know on AM or FM what the reach is, but I have heard.
Not that.
Here's a story.
It's not that good.
Here's a story. 1986. The Mets are in the World Series. It's Game 6, nearing the end. The Bill Buckner fiasco is about to occur. The radio station, this was not the national broadcast, the radio station out of New York is broadcasting.
Mm-hmm.
Usually, I can't get that station.
No.
But I'm on a bridge, and I'm trying to find the Met game, and guess what I find? The New York broadcast. The atmospheric,
What is that, WOR?
It was WOR, yeah. The atmospheric conditions must have just lined up perfectly.
Yeah.
And I'm getting the New York home broadcast.
Or you were catching it on a skip.
So I pull over on the bridge.
Okay.
I don't want to go any further and lose the signal.
So flashlights on, you're like broke down, huh?
And I literally listened to the ball go through Bill Buckner's legs, hit by Mookie Wilson, and led to the Mets win Game 6 of the World Series and go on to win Game 7 and win the championship. And I listened to it from the home radio station hundreds and hundreds and hundreds and hundreds of miles away.
Yeah, it would have been AM station, not FM.
Right, because somebody decided it was going to work.
The radio gods smiled on you.
So does that now mean that that radio station is entitled to a non-compete that goes all that distance?
Yeah.
Maybe it does. I mean, there's case law that says if the reach is, it does. Now, as an attorney, I would argue, well, that's an exceptional reason. The moon had to align, and the Jupiter had to meet in Mars.
You were in the right spot on that
It
bridge.
was the age of Aquarius, and then I'll break into song in front of the judge, and I'll say, this is ridiculous, Judge. I can't sing, and you can't enforce that kind of a geographic radius. Looks like we have a call, folks. And we have Mr. Bulldog on line 1. How you doing, Bulldog?
Hey, how's it going, man?
It's going good.
WOR, huh? I grew up on Long Island. I watched Shea Stadium being built.
Me too. I did too as a kid.
Anyway, I had a question about the non-compete.
Sure.
Because I certainly signed a lot of them, and it was not from, competitors in the same county thing. It was more intellectual property of what I had learned from,
I know exactly
used to
what you're
work
talking
for
about.
the Big Five,
Yep.
so some free letter, consulting companies that I will not mention made me sign that I would not take their technology over to another company. And, whether I was working in the same state or not. So I was wondering, how does that all play in? Because you can't, tell me to dumb down my routine when I work for another company, but yet I can't not work for this company, and do my job as I know it.
Okay, that's a really good question. It comes up a lot. It's not part of the non-competition itself. What you'll often see in restrictive covenants are several different paragraphs. One is the non-compete. One is a confidentiality agreement. One is a restriction on disclosing proprietary business information, trade secrets, that kind of thing. Another is a non-solicitation paragraph where you can't go after any of our employees for a certain period of time. And those are different aspects of an overall restrictive covenant. Now, as for the one you're talking about, which is, you can't take their intellectual property, it is 100% enforceable. Every business has a right to protect their proprietary business information and what are legitimately called trade secrets. Not what any business will call their trade secrets, but what are legitimately viewed as trade secrets. So now, you say to me, like other clients have said to me, what does that mean? I have to go work somewhere else and dumb down my knowledge? No, it doesn't mean that, really. It means that you cannot take to a future employer the specific information that would place your former employer in a competitive disadvantage. So, if you know, for example, that let's say they're a landscaping company, and you know that when they're bidding on jobs, they bid at 2.5% over cost. You cannot let your new employer know that, so that they have a better opportunity to underbid. However, what can you do? The law is very clear. You are not supposed to leave a former employee as a zombie. The general knowledge you acquire as a result of your employment that allows you to understand the business better, understand how to succeed better, you're free to take that with you and use it and take advantage of it. And
even when it comes to, say, a methodology that they have put in place that is, supposed to be all this in a bag of chips and everything, and you take elements from it, you use it in another company, that's totally viable, right?
No, you're likely in trouble. You are likely in trouble.
Well, I've
that is
a couple of times.
Yeah, well, okay. That is the proprietary business information. The methodology of how they do something is some of their most sensitive, critical information. And
but that cannot be written. What part of that is in the non-compete?
Well, usually a restrictive covenant will have a paragraph about confidentiality. And usually it will say this provision which survives forever, not just for the 18 months or the 24 months or whatever. This provision survives anything. And that's enforceable. You cannot. Well, let me say this. Lawyers hate saying things in black and white. So let me say, you generally cannot put your prior employer in a competitive disadvantage. You can't do that by
it's like giving up how McDonald's does its fries when you go to work for Burger King.
Right.
Or something.
But now, if you have learned things about, let's say, customer service in general, and how it is better to make an impression upon the customer, well, that's not a trade secret. You can now do that and be a better employee in your next job. But you just
that's a learned trait.
Exactly, it's a learned trait. That's a great phrasing for it, because that phrasing does come up in court cases. But what you always have to protect against is giving your employer or using yourself in the new employment.
It's pre-knowledge information in court. They're going to say you got this pre-knowledge from your previous job, and therefore you used it for this customer's benefit, so therefore you pirated technology, more or less.
Maybe, maybe not. See, what I'm saying is it depends upon what that knowledge is that you utilized. If it is knowledge that would be considered proprietary, confidential, trade secret, yes, you cannot do it. But there is a lot that employees learn in a job that makes them attractive to the next employer and that you can take with you. For example, now, I'm not an employee of WPSL, but let's say I was. And now this is my first radio show. This is my first shot at this type of a rodeo. And I think this is the 8th show.
Mm-hmm. And you're doing a very fine job.
Thank you. I appreciate it. I've learned a lot already about radio. I probably haven't learned 1/100th of what I would need to learn.
You'd have to sit over here.
She's talking about by the keyboard.
Yeah.
But I've learned a number of things that I have really found fascinating about doing a radio show. Can I take that to WNBC, New York City?
Yes, because that's how it works.
Absolutely. Absolutely. What can't I take with me?
I've learned something from every radio station that I've ever worked at.
And one would hope you do.
So.
But what I can't take is that I've learned certain secrets of WPSL in terms of how do they acquire advertisers? What is their methodology? If I go tell WNBC that, I'm in trouble.
But what if you waited out the time frame of that non-compete and you did it anyway?
You can't do that. See, that's what I'm saying. The confidentiality portion of a restricted covenant will usually not have any time frame, and that is legitimate. You just can't do it. Okay? A business is entitled to have its proprietary business information protected at all costs. That is not part of the non-compete time frame.
And a lot of times you will notice, in my business especially, is that you don't get to use your own computer. You have a computer, and it's assigned a certain way, and it's got all of this built into it, and all of the information on it. Boy, that's the first thing they want when they tell you to clear out your desk.
That's right. And there are employees, and I won't say just a few, who, when they know they're about to leave voluntarily, start copying all sorts of stuff from their little PC on their desk.
Or delete.
Or delete. But most significantly, copy.
Yeah.
And take that with them. Now, it really depends on what you've copied. If you've copied...
Say it's a client list.
Can't do it. No.
Okay.
My goodness, can't do it. Now...
Well, actually, they can come after you under that not part of the non-compete, but
part of the restrictive
else.
Covenant, a broader term.
Yeah, they will come after you if you have, any of their records.
That's right.
They have a legal right to do that.
That's right. Now, let's talk just briefly about the customer list. Mm-hmm. You cannot take the customer list. But does that mean that when you go to the new job, you have to forget the customers that are in your memory?
In radio, a lot of times the customer's buying that salesperson, and they'll follow them wherever they go.
That's true. And you don't have to forget that Bill Smith Chevrolet was a customer if it's in your brain.
Sure.
You just can't take a document.
Okay.
Mm-hmm. So, there are, and this is where you end up in massive litigation if it's valuable enough, because all these things are so fact sensitive that lawyers argue over them, and we dance on the head of a pin and make judges decide these things. Mm-hmm. But these are important things for both employees and employers, and my primary concern, and we'll probably end up definitely going into the next show on this. So, gosh, I may lie about getting to sexual harassment after all. But my primary point here is that a non-compete is a serious thing to sign. And while it may be presented to you at the beginning or in the middle of your employment, or if the employer is trying to be cutesy without letting you know you're about to be fired, right near the end. Okay?
That's just mean.
It's mean, but it's okay. I would beg anybody that's listening, read that non-compete carefully. Ask yourself, really, can I live with this under the worst of circumstances if I'm fired? And invest in at least a free call to a lawyer where they're going to screen you on the phone and basically maybe give you some input, like here at Ask a Lawyer. Or even, honestly, I've had many people come in. Invest in a paid consultation, which isn't all that expensive, to really have a lawyer look at yours, listen to you, and give you advice as to whether maybe you should sign it, you shouldn't sign it, or if possible, we should try to negotiate it, because it can save you a lot of aggravation
There's
later.
nothing like needing to make your mortgage payment and you can't go to work.
Or put food on the table.
Yeah.
Or you find yourself, well, the family's going to stay here in Port St. Lucie, but I've got to take a job in North Carolina.
Yeah.
And I'll come home on weekends or whatever
when
I
this
can.
thing runs out. Yeah, I'll be back.
Non-competes are serious business. Mm-hmm. And if you're an employee, treat it that way, please. Because most of the people that come to me don't come when it's presented to them. They come when they have a problem and they want to leave. And by the way, as we were getting close to winding down, if your employer thinks that you are in breach of your non-compete, first, you may get a letter, but guess who also is going to get that letter? Your current employer. And that letter is going to threaten a lawsuit against you and your current employer. And most new employers are not going to find you valuable enough to want to get embroiled in this, and you're going to find yourself fired.
Well, there have been some cases, again, in radio where that person has been paid for the turn. Now, they may be working in the building. You don't know they're really working or not working, but they're just not on the air, and they wait out the term of that non-compete.
True.
But you got to have a really great new employer.
Right. Now, and there are plenty of employees, and I've come across them, where you have a particular skill set. I mean, look, let's say you are a chemical engineer, and they really want you. And now they get this nasty letter from some jerk of an attorney like me who says, the employees violate our non-compete, and we're going to sue you and the employee, and we're going to get all this money from you. There are some new employers who will say to their new employee, our attorney will respond to this, because you're valuable to them. But I would never count on that happening.
Yeah, and in the meantime, you're really the janitor, and you'll get paid, but you can't do the job we've hired you for until this is cleared up.
That's right. And another thing which we will get into next week on this topic in a little bit more detail is, what's the first thing your old employer is going to ask a court? For a temporary restraining order to stop you from working for the new employer. And depending upon the facts, that will often be granted. And so now you are out of work for however long it takes to resolve this. So either it's going to be resolved by negotiation, or you're going to be out of work for quite a while until the litigation gets resolved.
Right.
And that doesn't help you.
Or the term of your non-compete runs out.
Right. Doesn't help you. And who knows, by the end of that time, that new employer may not want you anyway. So this is really serious. And I do get a lot of calls about non-competes.
So if people are presented with a non-compete, they really, really should get legal advice.
I think they should.
Yeah.
I think, first of all, really read it seriously.
Yeah.
A lot of people don't.
But this could affect your family. I mean, it really
could affect your entire future.
Right.
And the higher up you are in the food chain, the more significant that non-compete's going to be.
Well, both sides have more to protect there.
That's right. So, next week we'll go into the issue about injunctions and something called blue penciling. And really, really briefly, that is where the court has the right to modify the duration of the non-compete and the geographical scope. In most contract cases, the court says this is a good provision or it's not. If it's not, it's gone.
Okay.
In non-competes from common law England, courts have the right to blue pencil. So we have about a minute left, and I can never do anything in a minute. So
tell us where.
Let me tell you.
Talk about you a little bit.
My office is in Stuart. It's on US 1. The phone number at the office is 772-781-8003. If you call, you'll either get to chat with me a little bit, or you'll chat with my paralegal, Cheryl. See, Cheryl, I gave you a shout-out again, and Cheryl will take your information, come talk to me, and then either Cheryl or I will get back to you, or both of us, about what you may have. So I hope you enjoyed this little discussion. Hope you found it educational. Tell your friends to listen in if they're concerned about non-competes next week, or maybe getting into sexual harassment. And thank you for listening.